Online statements can disappear from a timeline, but once they are preserved and attached to a lawsuit, they can become part of a permanent legal record. Today, I am not here to replay internet conflict, choose a side, diagnose anybody, or turn a pending case into entertainment. I am here to walk you through what one civil complaint says, what the public record confirms, and what has not been decided yet. Welcome to My Chaos Brew True Crime.
Everything she ever wanted was already in her eyes. A reflection of her dreams, her memories, her truth. Mind Chaos Brew. Unlock the power within.
Okay, ladies and gentlemen, we are here for a good long, hey Riaz, hey Dr. Steele. We are here to get into some things, okay? This is a document-led discussion of civil action file number 26CB7084 in the Superior Court of DeKalb County, Georgia. The complaint was filed on August 1st, 2026, and is captioned as a verified complaint for defamation per se. Throughout this show, I will refer to the people involved only as the plaintiff and the defendant because the legal process is the story. The personalities are not. Hey, Ami, how you doing? Now, y'all, this is a lot. It's a lot. Okay, let me just check something. Okay, so I'm going to share this with you all. Before we go further, the word verified has a specific meaning here. Page 38 contains a sworn verification stating that the plaintiff believes the factual allegations are true based on personal knowledge, except for matters stated on information and belief. Verification does not mean that the court independently verified every allegation. It means the plaintiff signed the pleading under oath. This program is educational commentary based on publicly filed court documents. I am not an attorney, and this is not legal advice. A complaint is the plaintiff's account of the dispute. Even when it is verified, its allegations are not automatically established facts. The defendant may respond, deny allegations, raise defenses, challenge evidence, and ask the court to dismiss the claim. No final judgment on the merits have been entered. But before we begin, to those of you that are watching and will watch the replay, no contacting the members or the people that are listed in this case, no doxing, no diagnosis, no threats, and allegations are not findings. Please respect my chat. The chat rules are simple. Do not post addresses. Do not contact either party. Do not diagnose anyone. Do not insult anyone's appearance, family, health, or intelligence. Do not repeat an allegation as if a court proved it. Comments violating those rules will be removed. We can discuss legal process without becoming a part of the conflict. If we're clear, please put a 1 in the chat. Thank you kindly. Sorry, y'all have a whole bunch of documents. Hey, XRW, how you doing? Welcome to the live. Okay. The verified complaint was filed on August 1st, 2026. Page 1 identifies the Superior Court of DeKalb County, Georgia. The title of the filing and civil action file number 26CV7084. Those are procedural facts visible on the document. Okay? A separate affidavit of service was filed on August 4th, 2026. And according to the affidavit, the defendant was personally served on August 3rd, 2026 at 4:01 p.m. Eastern Time. Personal service means the record reflects delivery of the lawsuit papers and an opportunity to respond. It does not mean the defendant admitted anything, lost the case, or was found liable. Hey, YouTube Unfolded. Okay, Rainy Woman. Thank you kindly. All right. So now we're going to get into the complaint in and of itself. Hey, beautiful, because baby, there's a lot happening here. And I want to also be sure to keep everybody, protected. Pages 1 and 2 establish the plaintiff's basic theory of jurisdiction and describe both parties as public YouTube creators operating within an overlapping digital community. The complaint says they previously maintained an amicable online relationship and shared private communications before the relationship deteriorated. That is the plaintiff's framing and not a finding by the court. There's only certain paragraphs I want you guys to see. I'm going to show you too much. Not too much, huh? Perfect. Okay. Page 3 alleges that the plaintiff attempted to establish boundaries and block further communication. The plaintiff then alleges that the defendant used those events as the starting point for a continuing public campaign. Again, I am describing what the pleading alleges. I am not deciding whether that account is accurate. Okay? Now, child, let me sure. Because, I'm being very, very, very particular about what I show y'all. Okay. So, pages 4 through 8 describe the first group of broadcasts identified by the plaintiff. The complaint attributes statements to live streams, recorded clips, third-party panels, and later discussions. At a high level, the plaintiff says these publications accused her of threatening conduct and continued after she attempted to remove herself from the dispute. Now, moving right along. I ain't gonna keep you all day, I promise you. Y'all. This is a lot. Oh gosh. Too much. And I done changed the wrong page on the wrong thing. Okay. Pages 9. Pages 9 through 18 allege that the subject matter expanded and that the plaintiff sent cease and desist communications and formal retraction demands. The complainant characterizes letter publication as evidence of notice, repetition, and alleged malice. Whether those notices were legally sufficient, whether the statements were actionable, and what effect the notices may have are questions for the litigation. Pages 19 through 33 describe additional broadcasts, written posts, alleged online record searches, and the plaintiff's claim that the publications continued. I am intentionally not repeating the most graphic wording. Repetition can create a second wave of harm, okay? And we don't want to do that and distract from the legal questions the court may eventually address. The central questions may include what words were actually published, whether they were statements of fact or protected opinion, whether they were false, whether they referred to the plaintiff, what level of fault applies, whether any defense or privilege exists, and what legally recognized harm resulted. The complaint supplies one side's answers. Litigation tests those answers. Now, in this court document, honey, we have 3 counts pleaded, okay? This is the plaintiff's pleas to the court for relief. And honey, it's a lot. It's a lot. Count 1, Defamacast and Libel. Hey, honey. At the bottom of page 34. Oh, wait, hold on a second, y'all. I don't want to see that. Okay, thank you kindly. There we go. At the bottom of page 34, the complainant labels count 1 as Defamacast and Libel. The pleading treats permanent digital videos, written posts, pictures, and archived broadcasts as publications capable of supporting a libel theory. The plaintiff still has to prove the required legal elements. A count's title is an allegation and legal theory, not a ruling that the claim is valid. Give me 1 second. Slander per se. My God, today. Page 35 labels count 2 as slander per se. The complainant argues that certain alleged spoken statements fall within categories recognized by Georgia's slander statute. Whether the precise words, their context, and the available evidence satisfy the statute is a matter for the court process, not a conclusion for this program. Punitive damages. My God. The lower half of page 35 labels count 3 as punitive damages. The complaint alleges that the continued publication after notices and the alleged removal of content demonstrate malice or conscious indifference. Punitive damages are not automatic. The plaintiff has requested them, but the court or a jury has not awarded them. Now let's get to the exhibits, honey, because the exhibits are lengthy. The exhibit index begins on page 39. It describes the materials the plaintiff says support the complainant or support the complaint, including screenshots, archived broadcasts, transcripts, messages, legal notices, delivery records, and other documents. An index describes what a party says the evidence is. It does not establish authenticity. Now, for transparency, I do have to mention, Chaos Brew is a third-party source that previously displayed or preserved certain public materials. Because my channel appears in the exhibit index, I am not presenting myself as a newsroom with no connection to the record. My responsibility is to disclose that connection and limit this program to what the file document says. Okay? So, moving right along. Pages 41 and 42 continue the exhibit index. My God, today. And 43. We'll stop right here on 42, though. We'll get back to 43. Okay? The opposing party may challenge the source, context, completeness, meaning, relevance, or admissibility of any listed item. A court may also exclude evidence even when it is attached to or described in a public filing. I will not tell you that an exhibit proves a case. I can only explain what the plaintiff says it is offered to show. Now, page 43 completes the plaintiff's exhibits. But my God, it's a lot. It's a lot. It is a lot. Some materials may be accessible through a public file, but remain unnecessarily invasive for a YouTube audience. Public access is not an obligation to amplify every detail. So let's talk about the prayer for relief. The plaintiff asked for judgment on the pleaded counts, general damages, and an amount to be determined at trial, but stated as not less than $50,000. Separate punitive damages, litigation expenses, and court costs, and any other relief the court considers proper. Those are requests, not awards. Filing a dollar figure does not establish the value of a case. Any recovery would depend on the claims that survive, the evidence admitted, the applicable legal standard, and the decision of the judge or jury. Page 37 contains the plaintiff's demand for a jury trial on issues that are legally triable by a jury. A jury demand is procedural. It does not guarantee that every claim will reach a jury or predict any outcome. The next important development is the defendant's filed response, or a substantive motion. A response may admit procedural facts, deny allegations, assert defenses, challenge the complaint, or raise other claims. Discovery requests may seek documents and sworn answers, but those requests can also be challenged, narrowed, or limited under the applicable rules. I am not calculating a response deadline on this show because legal deadlines can be affected by procedural rules, service questions, extensions, and court orders, the official docket, and the party's legal guidance control. For this channel, a responsible update will be based on a filed answer, a substantive motion, or a court order, not a rumor or live stream reaction. So again, we're going to be sure that we are clear on the order of events. Complaint filed, service, response or motion, discovery, and court rulings. Give me one moment, please. So again, oh, that's what I did. Give me one moment here, please. Sorry, y'all. I had removed an issue. Not an issue, an image. Documentation, restraint, and due process. The larger issue is what happens when online communication crosses into allegations that can affect a person's reputation, family, health, housing, or livelihood. A platform may treat a broadcast as temporary content. A litigant may later preserve that same broadcast as potential evidence. Deleting a post does not guarantee that it disappeared. And repeating an accusation can create additional harm, even when the repetition is framed as commentary. There is also a lesson about restraint. Documentation is not the same thing as retaliation. Boundaries are not invitations to investigate someone's private life. A legal notice is not proof that the sender is right, but it signals that a dispute has entered a different level of seriousness. Once litigation begins, the cleanest public posture is often to stop feeding the dispute and allow the filings to speak. Here's the honest bottom line. A civil defamation lawsuit has been filed. The record reflects personal service. The complaint presents a detailed theory from the plaintiff's perspective, pleads 3 counts, requests monetary and punitive relief, and demands a jury trial. The defendant has not been found liable, and the merits remain unresolved. Butterflies, we will not use this case as permission to harass either party. We will not turn private information into entertainment, okay? If the docket produce a filed response or a court ruling, we can return to the documents and explain what changed. Until then, the accurate ending is this. Allegations have been made. Service has been reported, and due process is underway. All right? So I want to thank you. Hey, Coconuts. I want to thank you all for joining me for a calm, factual conversation. Protect your voice and your peace. And remember that accountability is strongest when it's accurate. Please be sure to like, subscribe, share, hype the video if you can, and I will catch you in the next one. Take care. Peace.